The suppressor revolution, the one big beautiful bill, the $0 tax stamp, and the lawsuit that could undo 91 years of federal gun law. Folks, there are two things you need to understand about what just happened, and I want to be very precise about both of them, because the internet is already getting this wrong. The first thing, on July 4th, 2025, President Trump signed into law the one big beautiful bill. And buried inside that 1,106-page piece of legislation, right there in Section 70436, Congress zeroed out the $200 federal tax stamp that has been required to purchase a suppressor, a short-barreled rifle, a short-barreled shotgun, or an AOW, and any other weapon since 1934. Gone. Effective January 1st, 2026. That is the most significant change to the National Firearms Act in over 90 years. The second thing, and this is the part I need you to sit with, the registry didn't go anywhere. The ATF Form 4 didn't go anywhere. The background check, the fingerprints, the approval process, all of it, still in place. Still the law. Still enforceable. So the question every serious gun owner should be asking right now is this. If Congress eliminated the tax, the one thing the Supreme Court used to justify upholding the NFA in the first place, what exactly is holding the rest of this law up? That question is now sitting in federal court, and by the end of this video, you're going to understand exactly why the answer could dismantle a law that has been on the books since Franklin Roosevelt was in his first term. The NFA came from. To understand why this lawsuit has the potential to do what it might do, you have to go back to 1934. Not because it's interesting history, though it is, but because the constitutional argument being made in federal court right now is built entirely on what happened 91 years ago. By 1934, Prohibition had just ended, but the damage was done. The Thompson submachine gun had become a cultural symbol of organized crime. Congress was staring at a crime wave that scared the country. And so they passed the National Firearms Act, the NFA. Now here's how the NFA actually worked as a legal mechanism. Congress didn't outright ban these weapons. They taxed them, heavily. The original tax stamp was $200, which in 1934 dollars was an extraordinary sum. The ATF has acknowledged that the $200 tax was, quote, considered quite severe to carry out Congress' purpose to discourage or eliminate transactions in these firearms. In today's dollars, adjusted for inflation, that figure exceeds $4,700. That is not a coincidence. That was the point. The tax was designed to be prohibitive. But here's the constitutional mechanism behind it. Congress didn't use the Second Amendment to regulate these weapons. They used the taxing clause, Article 1, Section 8, Clause 1 of the Constitution, which gives Congress the power to lay and collect taxes. 3 years later, in 1937, the Supreme Court weighed in. The case was Sonzinski versus United States, 300 U.S. 506. The court upheld the NFA. The reasoning was straightforward. This is a tax. Congress can tax. The NFA is constitutional. That case, that single 1937 decision, has been the constitutional spine of the NFA for 91 years. Now, understanding what the NFA actually covers matters here. The law regulates 6 categories of firearms: machine guns, suppressors, short-barreled rifles, short-barreled shotguns, destructive devices, and any other weapons. That catch-all category that covers things like pen guns and certain pistols. Every transfer of these items required a $200 tax, fingerprints, a background check, ATF approval, and registration. The one big beautiful bill zeroed out the tax, but only for 4 of those 6 categories: suppressors, SBRs, SBSs, and AOWs. Machine guns and destructive devices were not touched. The tax on those remains $200. That distinction matters enormously, and I'll explain exactly why in a moment. First, let's talk about how we even got to the point where Congress was voting on this at all, Because the legislative path this bill took is, frankly, remarkable. The legislative fight, how the bill actually passed. The Hearing Protection Act, the legislation that would have removed suppressors from the NFA entirely, has been floating around Congress since 2017. Every time it got introduced, it stalled. The gun community knew the argument. The political will was never quite there. In 2025, that changed. Or at least, it partially changed. H.R. 1 was a budget reconciliation bill, a massive, broad piece of legislation. Early drafts included the full Hearing Protection Act language, remove suppressors from the NFA, treat them like standard firearms under the Gun Control Act, standard NICS background check, no stamp, no fingerprints, no registration. The American Suppressor Association and Gun Owners of America fought hard to keep that language in the bill. On May 22, 2025, the House passed H.R. 1 with that full deregulation language included. By a margin of 215 to 214, one vote. Then the bill went to the Senate. And here's where the procedural reality of Washington hits hard. The Senate parliamentarian, that's the Senate's official procedural referee, ruled on June 27th that the Hearing Protection Act provisions violated the Byrd Rule. The Byrd Rule is a Senate procedural limit that bars policy changes that are not primarily related to the federal budget from being included in a reconciliation bill. Full deregulation, removing suppressors from the NFA, is a policy change, not a budget matter, struck. But here's what the Republican majority did next. They didn't walk away. They drafted a fallback. They inserted new language that kept the NFA registration framework fully intact, but eliminated the $200 tax stamp for suppressors, SBRs, SBSs, and AOWs. Tax change. That's budget. That passes the Byrd Rule. The Senate vote, 51 to 50. Vice President J.D. Vance cast the tie-breaking vote. 3 Republicans opposed the bill: Tom Tillis, Rand Paul, and Susan Collins, each for different reasons. The bill went back to the House for final approval. The final House vote, 218 to 214. 2 Republicans voted no: Representative Thomas Massie of Kentucky and Representative Brian Fitzpatrick of Pennsylvania. Signed into law by President Trump on July 4, 2025. Effective date for the $0 tax, January 1, 2026. Now, I want to be clear about what this means in practical terms. As of January 1, 2026, if you walk into an FFL to buy a suppressor, you still fill out the ATF Form 4. You still submit your fingerprints. You still pass a background check. You still wait for ATF approval. The process is identical to what it was before. The only thing that changed is the $200 payment is gone. That's nothing. That's real money. And for a lot of gun owners, it removes a genuine financial barrier. But it is not full deregulation, not even close. And the moment Trump signed that bill, the lawsuits started. The same day, July 4th, 2025. The lawsuit, the Legal Theory Silencer Shop Foundation versus ATF*, filed the same hour Trump signed the bill. Let's talk about who is actually bringing this case, because the plaintiff coalition here is substantial. The lead plaintiff is the Silencer Shop Foundation. They are joined by Gun Owners of America, the Firearms Regulatory Accountability Coalition, FRAC, B&T USA, Palmetto State Armory, Silencer Co. Weapons Research, and the Gun Owners Foundation. One individual plaintiff is also named. Then, on August 8, 2025, an amended complaint was filed, adding 15 states as plaintiffs: Texas, Alaska, Georgia, Idaho, Indiana, Kansas, Louisiana, Montana, North Dakota, Oklahoma, South Carolina, South Dakota, Utah, West Virginia, and Wyoming. This is not a fringe legal challenge. This is a coordinated, well-resourced, multi-stakeholder constitutional attack on the NFA. Now let's get into the actual legal argument, because this is where it gets serious. The plaintiffs make a facial challenge to the NFA. A facial challenge, and I want to define this clearly, means they are not arguing the law is unconstitutional as applied to one specific person in one specific circumstance. They are arguing the NFA is unconstitutional across the board, for everyone, in every application. That is an extraordinarily high bar to clear, and it is the argument they chose to make. The argument rests on two legal prongs. Prong 1, the taxing clause collapses. The Sonzinski decision in 1937 upheld the NFA as a valid exercise of Congress's taxing power. The plaintiffs argue that Sonzinski no longer controls this question because the One Big Beautiful Bill zeroed out the NFA's taxes on suppressors, SBRs, SBSs, and AOWs. No tax, no taxing power, no constitutional foundation. Now, there is a precedent that makes this argument particularly interesting. There is exactly one other example in American law of Congress setting a federal tax to zero: the Affordable Care Act's individual mandate. In NFIB versus Sebelius, 567 U.S. 519, 2012, the Supreme Court upheld the individual mandate as a valid exercise of the taxing power. Chief Justice Roberts, writing for the majority, concluded that even a mandate backed by a financial penalty is a tax if it raises revenue and fits the form of a tax. The question the plaintiffs are now raising is essentially the inverse of that logic. If a $0 tax can't raise revenue and no longer carries the operative features of a tax, is it still a tax? Or has Congress, by zeroing it out, effectively abolished the constitutional justification for everything built on top of it? The amended complaint adds a direct Second Amendment challenge. The plaintiffs argue that requiring federal government approval before a citizen can transfer or transport a suppressor, short-barreled rifle, or AOW violates the Second Amendment as interpreted by the Supreme Court in New York State Rifle and Pistol Association versus Bruin, 597 U.S. 1, 2022. Under Bruin, if the government wants to restrict conduct protected by the Second Amendment, it bears the burden of identifying a well-established and representative historical analog from the founding era. The plaintiffs are asking the court to apply that test to the NFA's registration and prior approval requirements. Two prongs: taxing power gone, Second Amendment violated. That is the case. The government's defense. The Department of Justice, the same DOJ that has described itself as the most pro-Second Amendment DOJ ever, filed a 48-page brief defending the NFA in November 2025. I want to walk through their arguments precisely, because understanding what the government is arguing tells you a great deal about where the weaknesses are. Government Argument 1, the occupational tax survives. The DOJ argues that even though the $200 making and transfer tax was eliminated, the NFA's special occupational tax, the tax paid by businesses that manufacture, distribute, or deal in NFA-regulated firearms, was not eliminated by the One Big Beautiful Bill. That tax is still in place. Therefore, the government argues Congress is still exercising its taxing power. Sonzinski still applies. The taxing clause still supports the entire NFA framework. Now here is the problem with that argument, and the plaintiffs spotted it immediately. The NFA's registration requirement, the requirement that a private citizen get federal approval before transferring a suppressor to another private citizen, exists to enforce the transfer tax. That's its function. That's its purpose. If the transfer tax is gone, what exactly is the registration requirement enforcing? The occupational tax is paid by manufacturers and dealers. It has nothing to do with the individual transfer process. Using a business tax to justify a regulatory burden on individual citizens is a significant stretch, and that is exactly what the court is going to have to sort through. Government Argument 2, the Commerce Clause as a backup. The DOJ argues that even if the taxing clause argument fails, the NFA's registration requirements are independently justified under the Commerce Clause. Article 1, Section 8, Clause 3, which gives Congress authority to regulate interstate commerce. Suppressors and SBRs move in interstate commerce. Congress can regulate them. This is the government's safety net, and it is not a frivolous argument. The Commerce Clause has been used to sustain federal firearms regulation since at least United States versus Lopez, 514 U.S., 549, 1995. And even there, the court upheld that Congress has broad but not unlimited Commerce Clause power. But here's what makes the Commerce Clause defense awkward in this context. The NFA was never justified on Commerce Clause grounds. It was always a tax. The regulatory framework, the stamps, the forms, the registry, was built around the tax. Retrofitting Commerce Clause justification onto a 1934 regulatory structure that was specifically designed as a taxing mechanism is precisely the kind of post hoc constitutional rationalization courts have been increasingly skeptical of in the post-Bruin era. Government Argument 3. Suppressors aren't arms. On the Second Amendment prong, the DOJ argues that suppressors, SBRs, SBSs, and AOWs do not fall under the Second Amendment's protection because they are not, quoting from the brief, typically possessed by law-abiding citizens for lawful purposes. That phrase comes from District of Columbia versus Heller, 554 U.S. 570, 2008. Justice Scalia, writing for the majority in Heller, suggested that the Second Amendment protects arms in common use by law-abiding citizens. The DOJ is arguing suppressors don't qualify. The government also cites United States versus Peterson, 150 F.4th 644, 5th Sirin 2025. A Fifth Circuit case decided in 2025 that held the NFA's regulations are presumptively lawful as applied to suppressors. That ruling is binding on the court where this case sits, the Northern District of Texas. That is the government's strongest card. Not the legal argument, the precedent. And I want to be direct about what that means. Even if the district court finds the plaintiff's constitutional arguments compelling, it may feel constrained by Peterson until a higher court revisits it. The wider litigation landscape Silencer Shop Foundation versus ATF is the flagship case. But it is not the only case. The Second Amendment Foundation is a named plaintiff in Brown versus ATF and is backing two additional NFA challenges, Jensen versus ATF and Roberts versus ATF, filed in the Eastern District of Kentucky. The named plaintiffs in Roberts include Jews for the Preservation of Firearms Ownership, the American Suppressor Association Foundation, Buckeye Firearms Association, Meridian Ordnance, and two private citizens. The American Suppressor Association filed its own challenge, the Missouri NFA Challenge, and on April 14, 2026, at the request of the court, ASA and its partners filed a supplemental reply brief. On the opposing side, Brady Center to Prevent Gun Violence, Everytown for Gun Safety, and Giffords Law Center filed amicus briefs, that's friend of the court briefs, supporting the government's position. Now I want to explain why the venue of Silencer Shop Foundation matters, specifically why the Northern District of Texas is significant beyond just geography. This court sits inside the Fifth Circuit, and the Fifth Circuit has been the most aggressive in reviewing ATF regulatory actions of any circuit in the country. This is the circuit that struck down the bump stock rule in Garland versus Cargill, which became the Supreme Court decision of the same name in 2024. This is the circuit that struck down the ATF's engaged in the business rule in Butler versus ATF in October 2025, where a federal district court held the ATF exceeded its statutory authority. This is the circuit where the Reese versus ATF case struck down the federal handgun sales ban for 18 to 20-year-olds. A ruling in the Northern District of Texas, win or lose, almost certainly goes to the Fifth Circuit on appeal. And a Fifth Circuit ruling on the constitutionality of the NFA post-OBBB would carry enormous national weight and set the stage for a Supreme Court review that could be the most consequential Second Amendment case since Heller itself. One more development worth noting. Separate from the lawsuits, 21 members of Congress, led by Representative Andrew Clyde of Georgia, sent a letter to Attorney General Pam Bondi urging the elimination of NFA registration requirements entirely, independent of the court battles. That letter represents a legislative pressure track running parallel to the judicial one. The Bruen question and the suppressor's constitutional status. Let's talk about the Second Amendment prong of this litigation, because it raises a question that courts are currently divided on, and that division matters. The Bruen test, as the Supreme Court articulated it in 2022, works like this. If the Second Amendment's plain text covers an individual's conduct, the government must demonstrate that its regulation is consistent with the nation's historical tradition of firearm regulation. No balancing tests, no means-end scrutiny, historical tradition, or the regulation falls. The threshold question in this case, before you even get to historical tradition, is whether suppressors are arms covered by the Second Amendment's plain text in the first place. Courts are currently split on this. Some district courts have ruled that suppressors, as accessories rather than firearms themselves, may not be directly protected by the Second Amendment. Others have found that NFA regulations on suppressors are subject to full Bruen scrutiny. The Fifth Circuit's Peterson decision from 2025 took the position that the NFA's regulations on suppressors are presumptively lawful, without clearly resolving the "are they arms" question on Bruen grounds. And here's why this matters enormously for the constitutional analysis in Silencer Shop Foundation. If the court finds suppressors are arms under the Second Amendment, the government then has to produce a well-established historical analog from the founding era for a federal registration and prior approval requirement before a citizen can transfer a suppressor to another citizen. There is no such analog. There were no suppressors in 1791. There was no federal firearms registry in 1791. There was no ATF in 1791. Now, the government doesn't have to find an analog that is a perfect historical mirror. Bruen says, well-established and representative, not identical. But it does have to be something. And the further you get from the founding era, the weaker the analog. 1934 is not 1791. It's not even close. The plaintiffs also filed a supplemental authority notice pointing to Road versus Bonta, the Ninth Circuit's 2025 decision, striking down California's background check requirement for ammunition purchases. The relevance is this. Road applied Bruen's historical tradition test to an ammunition regulation, not a firearm itself. That broadens the scope of what Bruen's scrutiny applies to. And the plaintiffs are using it to argue that Bruen covers the NFA's prior approval regime, not just direct restrictions on arms. If suppressors are arms and Bruen applies, the government likely cannot meet its burden. That is the plaintiff's strongest ground. What happens now? Timeline and stakes. Here is where things stand right now. All summary judgment briefing in Silencer Shop Foundation versus ATF is complete. Plaintiffs filed their motion for summary judgment in October 2025. The DOJ filed its cross motion in November 2025. Plaintiffs replied in December. The government filed its final reply brief in January 2026. The case is now before Judge James Wesley Hendricks in the Northern District of Texas, awaiting a ruling. A summary judgment ruling, meaning a ruling on the legal arguments without a full trial, could come at any time in 2026. Regardless of which side prevails at the district court level, the losing party will appeal to the Fifth Circuit. That appellate process typically takes 1 to 2 years. If the Fifth Circuit issues a ruling that either strikes down portions of the NFA or upholds the law in a way that conflicts with rulings from other circuits, the case becomes a strong candidate for Supreme Court certiorari, the court agreeing to hear the case. Now, and I want to be unambiguous about this, nothing in these lawsuits has changed the law yet. The NFA is fully in force. The compliance requirements are fully in force. If you want to purchase a suppressor today, you fill out the ATF Form 4. You submit to a background check. You wait for ATF approval. The process is exactly what it has always been, minus the $200 payment. No court has issued an injunction pausing enforcement of the NFA. No stay is in effect. Do not act on the assumption that these lawsuits will succeed. They may. They may not. But acting on that assumption before a court order says otherwise is how people end up facing federal felony charges. What is genuinely different? What makes this moment unlike any other moment in the 91-year history of the NFA is the constitutional ground these cases are standing on. For 91 years, the NFA has rested on one constitutional leg, one case. Sunzinski versus United States, 1937. Congress can tax. The NFA is a tax. The NFA is constitutional. Congress just set that tax to zero. The government is now arguing that the remaining occupational tax and the Commerce Clause can substitute for what was always, explicitly, a taxing power justification. Courts are going to have to decide whether that substitution holds, whether the Sunzinski holding survives when the tax it was upholding no longer exists, whether the Second Amendment, interpreted through Bruin's historical tradition framework, has anything to say about a registration system that has no founding-era parallel. The NFA has survived court challenges before. It may survive this one, but it has never faced a challenge built on the precise constitutional foundation that was just removed by the same Congress that passed the law in the first place. That is not a prediction. That is the current state of federal law. And it is a state that gun owners, attorneys, FFLs, and courts are going to be navigating for years to come.